Well, I'm pleased to welcome Frances McLeod back to the studio.
Hi, Richard.
Frances. So, we're now going to talk about cross-border e-discovery and data issues. And this is not only a multinational challenge. We just had a case right here in New York where the Second Circuit threw out the conviction of two bankers convicted of conspiracy and wire fraud in a LIBOR case. And the reversal was based on compelled testimony given by the defendants to the UK's Financial Conduct Authority, and which was read by the Department of Justice's cooperating witness. What a mess.
Yep.
Right? So, confessing to my own struggles to understand these issues, let's just look at the current state of affairs. We have the Privacy Shield, Safe Harbor, and now the EU General Data Protection Regulation, or GDRP. So first, before leaping into any controversy, can you define those for us and maybe where each currently stands in this field of regulation and enforcement?
I will. And so this is
Thank you.
well, I'll have a go. It's a huge topic, and it's one that's part of an uncertain and changing landscape. And we call this internally the geopolitics of data, because it really is. And the way that I like
nice name for it.
Well, and the way that I like to try and characterize it is, I think, especially to Americans who, for a start, I think we've mentioned this before, discovery is a common law concept. So people from civil law environments have never been through that before. And I was trying to explain to companies kind of navigating going through discovery for the first time, if they're not American companies or they haven't been involved in American regulatory scrutiny or litigation, is to characterize it as, there's a lot of history around this. The reason that Europeans in particular are so wedded to privacy rights is really to do with history. If you look at, the Soviet Union, look at somewhere like East Germany, where 1 in 4 people was an informer for the government. You look at, obviously, the Nazi era and the, as I said, under the Soviet era, the amount of surveillance, the lack of rights and so on. I think that's really why, when you look at the EU drive towards giving a lot of rights around privacy, kind of comes from that historical standpoint. And then, you look ditto South America, where you've also had a lot of human rights violations around that. So we're seeing, within the last few years, just a plethora of nations bringing into force privacy regulation, and there are well over 100 now, which 10 years ago was not the case. So to go back to your original question, because the US is viewed by Europe in particular as not having the same standards around data privacy, historically there was a mechanism called Safe Harbor, which was a self-certification which would allow for transfer from Europe into the US. We were never huge fans of Safe Harbor because although it was a mechanism which would allow you to transfer data, it was predicated on the assumption that the standards or the rights associated with the data in the US would be the same as they would be in Europe, which was not the case. So we always advised our clients, comply with European data protection regulations, which were different in each of the member states, but similar in most, and give employees the right to issue consent forms, understand where the data is going, cull for private data before transmitting anything into the US. At this point, Safe Harbor is irrelevant because post the leaks, the Snowden leaks and the whole NSA scandal, the European Commission looked at Safe Harbor and struck it down as saying this is not a valid mechanism for transfer. It's the rights of the individuals whose data is being transferred into the US are not adequate. So there was a lot of negotiation about finding a substitute mechanism, and that's where the Privacy Shield has come into play. The reason that Privacy Shield is still controversial is, I think, in the wake of some of the recent executive orders under the Trump administration, the jury's still a little bit out within the EU as to whether Privacy Shield is going to afford similar rights to the data owners should that data be transferred. So we are being very circumspect about it. We've qualified for it, but we're still advising our clients to really adhere to the most conservative protocols for transferring data into the US, and probably doing it via a mechanism other than the Privacy Shield, mainly because it's completely untested. We haven't got any case law around it. We wouldn't want to put our faith in a European judge having the same view and the validity of the transfer mechanism. And then the final question, which could be very long and very boring, so I'll try and make it as concise as possible, is the European directive that comes into force next year. And that really is an attempt to harmonise all privacy regulation across the European member states. Each state had different regulations. Some of them were broadly similar, some of them weren't. Some of them were more onerous than others. And so this is really an attempt to give equal rights to all EU citizens over their data. And that will, as I said, involve a lot of work. Some of the provisions under the new directive or the new regulation, I should say, put a lot of burden on companies in order to assure certain rights to their employees. And there's obviously a lot of work already underway at some of the major corporations, but it's certainly going to make data transfer even more complicated because there are much more robust rights enshrined in the regulation that will be Europe-wide.
So what's the relationship between the Privacy Shield and the GDRP?
So Privacy Shield is a mechanism which would allow for transfer of data from Europe into the US, potentially. We don't know whether whether the new privacy regulation would favour that as a mechanism. So there are lots of clauses set out in the new regulation which enshrine rights, for example, the right to be forgotten as an employee, which could be incredibly onerous. So if, for example, you had to comply with a subpoena in the US and you'd had somebody had left the company that may be subject to that person might potentially have the right to say, well, I want my data all to be expunged, I have the right to be forgotten. And that would be in conflict, obviously, with complying with a subpoena.
Sure. Back to what a mess.
Yes.
So my understanding is that the GDRP takes effect, as you mentioned, May 2018, right? So in terms of multinational readiness, who needs to be thinking about this issue, Francis, that might not be thinking about it? So for example, is it a multinational that has offices in the EU, that sells into the EU, that may have personnel in the EU? Like, what's the nexus here for really having to think about this issue?
I think that's absolutely right. I mean, it's all of those things. So it's do you have operations there? Do you have data there? Do you have employees who are nationals of the EU because the rights attached based on nationality? And so it's pretty much anybody who has any company that has an exposure to the European Union by way of operations, people, or data.
So if you're selling, if you have operations, if you have employees,
correct,
you need to be thinking about this.
Correct.
Okay, so who needs to be trained on this? Is this an IT issue, sort of internal audit and forensics? Is it sort of C-level executives? I mean, this seems massive, Francis. So who owns it internally? I just read about a privacy champion. What's that, or rather, who's that?
So part of the new regulation will enforce that all companies have to have a data protection officer. Now, many large corporates already do have a data protection officer, and actually, interestingly, we deal obviously a lot with compliance officers. Quite a few of those in the last couple of years have been bemoaning the fact not only am I responsible for antitrust compliance, anti-bribery and corruption compliance, anti-money laundering compliance, I've now got data protection as well.
Privacy officer.
It's obviously a huge area, and obviously the other complication is we have so much data these days, and it's getting more and more data, and it's mobile. There's the cloud. There are a lot of questions around that. So the privacy, what do you call him? The privacy advocate, champion, the champion,
privacy champion,
the champion. So, to my mind, that's probably the data protection officer. But the fact that they use the language around having a privacy champion, to me, suggests, and there's been a fair bit written about this, that privacy really is an issue for everyone. It's certainly the issue for C-suite, because if you have the fines, which I should have mentioned, associated with breach per the new regulation can be enormous. I mean, percentages of turnover, global turnover. So obviously untested at this point. We don't know whether they're going to enforce. I think a lot of large multinationals are trying to work out what the true risk associated with it, because if they do enforce, clearly, that's an enormous risk that needs to be mitigated. But IT, definitely. Internal audit, probably, because they get to, first of all, if only in doing their jobs, they have to pull data and look at data. And if they're doing internal investigations, they might have to look at emails and other things. As I said, C-suite, because of the potential liability associated around this, but also there will be a requirement for messaging around this as well. So back to our favorite topic, tone at the top. Tone at the top around privacy and the importance of being compliant with the new regulation is going to fall to C-suite, and probably risk management too. So I think there'll be a number of key stakeholders that need to get involved in developing a strategy for implementing this.
Is this something where every employee will sort of know what their privacy rights are? Does it move it down to the individual?
They need to know, I guess, when a circumstance would arise where they should be aware of their rights. So, for example, obviously in our world, a lot of that is around an internal investigation, for example. Now, how it's going to actually come and play out, probably a lot more complicated than in the future when the directive's fully into play. But certainly from our perspective, for example, dealing in France, which has currently or had very robust data protection rights, we were required to get consent from employees. We had to give them the right to remove private data and segregate it. We would run search terms to try and cull out anything that was private. The consent that the employees gave was very specific as to the use permitted for their data. And we did a lot of filtering and screening in order to give them assurances that their data couldn't be used for other purposes and or inadvertently private information wasn't going to be passed over to whichever authority was looking into it. So we always made sure that the data owners were very aware of what their rights were. So I suspect it'll be situation specific, but there probably will need to be training around this for employees. And a quick fix, for example, of say in contractual employment contracts saying, for example, but it's okay because in certain circumstances we can use that data, that's not going to fly. It needs to be informed consent, so they need to understand what they're consenting to, how the data is going to be used, and potentially they have the right to refuse, which could make life quite complicated.
Now, you mentioned cloud-based solutions before. So you're talking to someone who just figured out that the App Store isn't a place I can have a cup of coffee in the afternoon. So with that level of technical expertise, can you have sort of segmented cloud-based solutions for how you store your data?
Yes, and I think that's something that the providers have clearly been struggling with for a while. I think if you'd looked at this issue 5, 6, 7 years ago, there was a sort of cavalier attitude, possibly based on this idea of a nebulous cloud, without thinking, well, the cloud does reside somewhere because there's a server somewhere in some physical location with data on it. And we were sort of a little bit preaching to the unconverted during a number of the cross-border investigations and compliance reviews that we were involved in saying we really need to reverse engineer where your data is to work out what rights go around this data. What we have seen certainly is much greater awareness in contracts with cloud providers as to where the data is going to reside. I suspect we're going to see much more segregation of data. I suspect there are going to be a lot more complicated negotiations around who's responsible for what in this area. And we've certainly seen, and we talked before about some of the sort of the complexities around this, but in the Brexit context, for example, the speculation is that the UK post-Brexit may not be viewed as having the same standards of privacy as the rest of the EU, and it may fall into a semi-US type of standard, or it may be viewed by that as the EU.
Because they're out of the GDRP.
Because they're out of the GDRP. So theoretically, they need to get regulation in place that's going to be of the same level, but we don't know how much on the front burner that's going to be given all of the other things that need to occur around Brexit. So we've noticed a halting of establishment of a lot of cloud resource in the UK, probably around questions around how robust the UK's data protection environment is going to be viewed post-Brexit.
What are corporations doing that have operations in the UK now? Are they sort of trying to harmonize their data protection and to say, even if we're not in the regime, we need to prepare as if we were?
That's a really good question. That's what we're advising. We're saying be very circumspect about this. Don't punt, don't bet on being viewed as being quasi-EU, because there's still so much to do. I mean, I think the bigger issue, and we're always looking at this through the lens of responding to regulatory scrutiny, is you've got to try and think of the worst case scenario and project it forward a few years, because you can make a decision today which seems absolutely fine based on the current environment around data protection, but we all know these big multi-jurisdictional investigations can go on for years, 3, 4, 5 years. So we've essentially said, if it's in the UK, keep it in the UK. If it's not in the UK, don't bring it into the UK, because you may end up inadvertently having moved data in a way that's not going to be compliant later down the road.
So just as an aside, whistleblowing, it's a big part of our sort of global enforcement life. Does any of this impact whistleblowing hotlines, the transferring of whistleblowing information?
That's a really excellent question. So generally whistleblower hotlines are done on an anonymized basis.
Right.
But I'm wondering, and it's not something, it's a hard question, I'm wondering if some thought is going to need to be given around where that data's housed, how it's disclosed, if people don't want to be anonymous, what does that mean?
Sure.
That's a very interesting question. I'm wondering if some of the service providers that specialize in this area aren't already thinking about getting advice around that.
Something to make it more confusing.
Yeah.
So tell me about FRA in this. I mean, it looks like you've got till mid-2018 to prepare. And by the way, if you get it wrong, is there a sanction regime right now?
Not now, but there is an expectation that companies will be compliant by May of next year. There's probably a grace period to allow. Obviously, this is a large financial commitment, and there's a lot that needs to be done around it. But at some point, one has to speculate that there will be enforcement around breaches. And as I've said, potentially that could be very costly, as much as 4% of global turnover. As far as we go, obviously, we ourselves are rushing to become compliant in our various locations. We have a Paris office, we have a London office, and then we have offices in Washington, D.C. and Providence, and we also have data centers in Canada and in Switzerland. So we are taking advice around this. All of our documentation is being updated to reflect new rights. We are getting, we are preparing ourselves, data protection officer, et cetera, et cetera. So, because we have to be, the best in this space. We have to be compliant, obviously, as not only as compliance professionals, but also as data processors and handlers, because the liability potentially could reside with us if there were an issue.
In your own internal investigations, right?
But I suppose the upside around all of this is given the fact that we have, really since inception in 99, been dealing with the complexities around conflicts of law around data transfer. We have a lot of experience in helping corporates navigate some of the challenges around that. Now, it's going to make life much more complicated. It's going to make the advice much more complicated. We also work with a Data Privacy Council in all of the jurisdictions in which we operate. The plus side, I guess, is we'll have harmony within the EU.
Sure.
But yes, it's going to make all of the activities that we do around our eDiscovery practice more complicated, and we're already looking at processes around that. That being said, we've managed to deal with Swiss banking secrecy since we were founded. We've managed to deal with the French blocking statute over, we've been in France for more than 10 years. We've dealt with data privacy issues in Brazil, in South Africa. Even the Middle East has some constraints now. Qatar has a nascent data protection policy as well. So I think we're looking forward to the challenge. We're looking forward to putting on our thinking caps. We're looking forward to working with our IT infrastructure folk, our data analytics folk, our forensic accountants, our eDiscovery people, to continue to come up with solutions that allow our clients to be compliant, and to make sure that they're getting the best advice that they can around that. So, it's going to be challenging. I suspect it's going to be a headache. I suspect there will be frustrations around it. But we see it, frankly, for us as another consulting opportunity.
Sure.
And just one sort of final thing is partly as a result of these issues, partly as a result also of state secrecy constraints in places like China and former Soviet Union. We've actually developed a mobile solution. So we do have the ability to process significant amounts of data in country, pretty much anywhere in the world. We can be up and running in 48 hours. And we've tried and tested that solution over the past years, making the footprint smaller and smaller as well. So we're able to get great throughput on that. and really allow at least companies that have issues to at least work out what the universe of their data is
Sure.
that would be responsive in country to minimize what is transmitted overseas, if indeed that can be done. And we have all the culling techniques around that too. So I think that's something that we're going to increasingly be deploying to help navigate some of these issues.
So for a company that doesn't have a current internal investigation, it sounds like FRA can help them prepare in terms of how to manage their data so they don't have an issue should there be one?
Yes.
Okay.
And in fact, it's interesting. We were approached probably 3 years ago now by a large French utility. And they were obviously saw this was coming. The regulation hadn't been all hammered out yet. In fact, we ended up doing a sort of data governance exercise for them, partly to work out what they had, where it resided, what the nature of the data was, what the risks associated with it were, what its age was, because I think companies also tend to hold on to far too much, which has cost implications. And then we also did some analysis around who was in the legal department, what their legal qualifications were, all of the privilege issues, which are different in different jurisdictions,
I've seen that.
and did a kind of risk mapping exercise to work out really what the most sensitive data was, where it was, where it should be, and create some kind of rules around that. And that was a multidisciplinary team from the client side between IT, legal,
Sure.
etc. So I think there are a number of companies out there. I know there are a number of companies out there thinking very carefully about this, but are leaning on people to give them some corporate governance advice. Not corporate, data governance advice, rather.
Sure.
Yeah.
Well, we'll look forward to following along in some of the thought leadership pieces that the FRA continues to provide. So thank you for your time.
Thank you,
It's
Richard.
great to see
It's a
you.
pleasure. Thanks.
Thank you.